Well, welcome to the University of Chicago Law School. My name is Seth Orenberg, and I'm the president and founder of Law Inc. Law Inc. is a law and business society dedicated to bringing the law and business schools closer together. I'm really happy to see we have some Booth students in the audience. Thank you. Welcome. We hope you come to more of our events. Today's presentation is going to be great. We have a panel of experts in lots of different types of technology law here to talk to you today. So I'll introduce them. From your right to my right, we have Rick Karr. He's a graduate of the law school, and he's the record holder for the youngest assistant attorney general. That was for the Antitrust Division. He's the antitrust counsel, outside counsel for Microsoft, and has worked on many seminal matters, such as the consent decree. And he's a senior partner at Kidwalder, Wickersham & Tapp, a prestigious DC law firm. We welcome him to bring his practical experience to the table. Randy Picker is also a graduate of the law school, as well as the college. Apparently, he couldn't get enough of University of Chicago and decided to return to become a professor of commercial law. He also wrote a book on game theory, and he helped draft Article 9, the secured transaction section of the Uniform Commercial Code. He teaches antitrust, network industries, and technology policy, in addition to several other courses. And we welcome him to the panel for his broad and deep scholarly experience. Nilay Patel is a graduate of the college and a graduate of Wisconsin law. He practiced copyright for a while and then wised up and decided to get out of big law and become a technology blogger. He was most recently the managing editor of the popular technology blog Engadget, and now he's working on a new project.
It's me. I'm just here for jokes. These guys are smart.
It's a secret project, but we're hoping he'll spill the beans today. And we'd like him to, share his experience with how consumers relate to technology and the law, and also maybe how to get out of big law and become a technology blogger.
He quit. Desperate. Things happen to you.
Rick Karr is our moderator. We bring him all the way from New York City, where it was 75 and sunny today, to Chicago for today's presentation. He's a technology journalist, a professor of journalism at Columbia University. He recently produced the Emmy-nominated documentary Net at Risk in 2006. He also has produced numerous things for NPR and PBS. The only thing he hasn't done is graduate from the law school or the college. But we'll have to forgive him for that. We're honored to have Rick here to lead our discussion. Without further ado, please.
Okay, thanks everybody for showing up. I actually want to start, I think we should start with copyright because that's what we were talking about downstairs. And I'm wondering if, are we going through another big wave here? I mean, what's the lay of the land right now, Nilay? What do you think the lay of the land is copyright-wise right now?
I think consumers are. So the first wave you're talking about is the 90s. It's actually...
No, I start with Gutenberg. See, that's where I start. But I don't know where you want to start.
The first wave of the digital copyright wars. Yeah, the RIAA sued Gutenberg for transferring books.
Damn Johannes!
Yeah. It's Universal Music Verse
exactly.
v. Gutenberg.
Pretty good. No, so when I was an undergrad here, that was when Napster came out, and I think that was very much the first wave. It's, okay, oh my God, I can copy these files between my friends very, very easily. And obviously there was tremendous copyright holder pressure against that, and that died down, and then Apple said, well, we can actually sell these files, and people will buy them. And a little bit later they said, well, we can even sell them without digital rights management, and people will still buy them. And they're tremendously successful. And then that moved on to music and movies and subscription services. And now I think you have an entire generation of users who are trained to think, all of my media is digital. And all of it should be digital, and there's all these things I want to do with it, and I can't do with it. You have a Netflix subscription, well, every device has to be Netflix enabled. You can't transfer that content, you can't move that content around. I think it's ridiculous that if you have a DVR, if you record something on your DVR, you have fair use rights to that content. You can transfer it to your iPod, you can put it on your phone, but you have to be at home lucky enough to catch it at the right time, even though most people are paying for cable for that content to come in. I think there's a lot of discussion in the industry. You have companies like Google who put out basically the Google TV, which is a computer that hooks up to your TV, and the networks and the content holders who said, we're going to block this product because we don't understand how it fits into our revenue stream. And I think there's just a lot of conflict there about who owns the content, what rights are we selling the content.
The DVR situation is so interesting, though. So I know, I go to conferences, I talk to other copyright professors. I think a lot of people think that if we relitigated Sony, not about the VCR, but about the DVR, it's not clear how that case would come out. right? Part of the premise of the Sony case was that there weren't these alternative markets where you could go get the content, right? They weren't selling VCR tapes and the like. So when you recorded something on television, you weren't necessarily substituting out of an alternative market. Now, of course, all of these markets are out there. And so, if we relitigated the DVR case, obviously you'd have to update for who's on the court now. But just on the integrity of the argument itself, right? It's not clear what would
relitigating
happen.
for who's on the court now is which business is bigger.
Well, I don't know. Maybe I'm not that cynical. I mean, so
I'm a blogger.
Yeah, exactly. You specialize in cynicism.
That's all I do. Cynicism and snark all day long. Well, no. Let me ask you this. I mean, you say there's a market, but is there? I mean, the market for music is iTunes and Amazon. If I wanted to go and compete with Reckless Records on Milwaukee Avenue, if I had enough capital, I could set up shop next to them. For sale means I could go and buy all their inventory and
Well, we
sell
say
it.
there's a market. I mean, what wasn't the case back, in the days that the VCR case was litigated is I couldn't go get this content in a legitimate way, right? So when we now we'll head inside fair use, right? When you turn to fair use, obviously you're a copyright lawyer. I mean, it's a 4-factor test. And one of the questions is, well, what does this use do to the market for the work? And so now, I mean, through iTunes and the like, or through Netflix and the like, I can get so much of this content.
Well, I mean, but right now you can say, well, there's DVRs. Everybody has one.
Right.
And the market for the work is almost unaffected. In fact, it's growing, right? Because
Well,
people are going to Netflix, they're going to Amazon, they're going to iTunes.
But this argument about the relationship between the market for the work and its use, I mean, you go back and look at, I've looked at the migration from sheet music to piano players, right? I mean, that was in some sense, if you ask about the technological migrations in copyright, sheet music was huge at one point, right? And then the piano player comes along and the wax cylinder comes along, and you see exactly these same arguments there. And so I don't think the structure of the argument has really changed in a century. It's really quite shocking how consistent the argument is. And in some sense, the question is do we want to assign the right to the copyright holder as to who gets to make the choice as to whether that argument is right or wrong?
I'm just a...
You're just an antitrust guy, yeah.
I will say, though, interesting, when I was a student, my third year, I wrote a paper for Posner on before...
Dick Posner at that
Yeah,
point.
Dick,
Not-
yeah,
not-
not his son.
Posner, yes,
Yeah, but on fair use and VCRs.
Did you
Before the
really?
kids, yes, but that was a long time ago. But
How many grades did you get?
I think I did pretty well. I don't know. I guess the one thing I would say is what has happened has pretty much destroyed the music industry, hasn't it? I mean, part of the problem, is again referring to one of my former professors, who I guess still teaches here, Frank Easterbrook. But
Oh, yes.
but when Easterbrook was in the Solicitor General's office, there was a debate about protecting copyright. And Frank's point was, if you don't protect the rights in some way of the artist, then no music will ever be produced.
But is
very-
protecting the right of UMG or any of the big record companies actually protecting the rights of the artists? I mean, I think a lot of artists would argue it isn't. And the point I'm trying to make is, it may have destroyed the music industry, but has it destroyed the market for music?
Right, I mean, there's more music. I get sent more actual music. We do
Right.
a podcast, we do a show. People are like, look at this music, put it in your show, give me the exposure I want, I'll go on tour. And that's what the artists want to do now, because they know that assigning those rights to a label isn't necessarily their path.
Well, I mean,
to
it would be an
fortune.
interesting question to see what has happened to the output of music. I think a lot of people, in terms of what music is available, sure, there's a lot of people. There are always going to be artists. I mean, this was part of the point to Frank. It's not the case that if you got rid of copyright, there wouldn't be people writing songs, right, or performing music. There's no question about that. But the question is, what happens at the margin if you essentially destroy the rights and destroy the ability of people to earn a return? So, what little I know about copyright from back in the day, I do think that some of the arguments that are being made about some of these things being fair use probably are wrong, because I think they are destroying the market.
Well, let me ask this, and I'm actually really curious to get your answer to this. There's this conflation in copyright law of the content, the idea, and I guess the idea is a really bad word to use there, but sort of the content
exactly.
and the physical, tangible copy, right?
Yeah.
The book is the copy. The
You
book
mean the
is
expression.
that's good. The expression and the physical,
And
tangible
tangible
object.
medium.
But that has been completely destroyed. And our copyright law regulates copies. It regulates, you're going to write this book down again.
What's happened is we've got a copyright statute, and it's been premised on this since at least 1909, where there was a match between the rights model and the physical instantiation. Right. Those have separated, right? And we still need to figure out what we think the rights model should be. That's a separate question from business models. I'm not talking about business models. I'm talking about how do we think we should give you rights.
But all the business models are built on right?
Exactly. And those have decoupled.
But I think they've decoupled
because
in
of
such a
technology.
violent and paradigm shifting way that the consumer no longer understands the business model, right? They look at the market of things they can buy, of content they can buy,
I don't know
and
what
they say,
think. Right?
Well, I do.
What I mean by
they
that
tell
is,
me very, very
but
loudly.
okay, but what I mean by that is do they, I mean, you see these surveys, right, which they recognize that if I go into, I don't even know if record stores still exist, right? If I go into a record store and shoplift a CD, they recognize it as a different act than swapping files on a peer-to-peer network, right? They think those are different. The question is, why do they think those are different? And is that the experience of the technology, or is it something else?
Well, I mean, I think it's something else. It's something really tangible. It's that people are used to communicating on the internet, and we've also built a culture on the internet, online, that is almost anarchic and is, I mean, the internet is built around the idea that we will not regulate this. We will see what happens, right? And so people on the internet get to do whatever they want, which is, I mean, they really think they can do whatever they want, and there's no rules around it. So when you have like this Sony case, this kid hacked the PS3, right? And Sony sued him.
Right.
Terrible PR move for Sony, well within their rights. Sony has now been attacked, right? The entire PlayStation network has been taken down. They're stealing credit card numbers, or they think they're stealing credit card numbers. That's basically an act of terrorism, right? But the back end of it is that when Sony did sue this kid, George Hotz, they did what you would do. I mean, any lawyer in this room, they sued him. They subpoenaed YouTube to see all the people who looked at his video. They subpoenaed his credit card processor to see who bought his code, all the things that you would do. And people freaked out. Oh my God, Sony is way off the line, right? They're over the rails. They're doing things nobody would ever do. And it's like, well, yeah, I mean, if you were selling physical stolen merchandise, this is exactly what you do.
Well, but
it's just because it's this intangible online thing that people believe that regulation
and
is
what I take it Rick does every day is you have to tell your clients, obviously, look, what your rights are on paper and your ability to enforce those, that's not necessarily in your best interest. That's what Sony's seen, and we've seen that repeatedly in these cases. And so you have to make a decision, a business decision, about whether it's really sensible to enforce your rights or not.
But I'm saying almost every case I've seen of an organization or an individual enforcing their rights for online activity has been met with reaction that is improper.
I understand.
Okay, but let me just ask, well, why is the fact that consumers are unclear about what their rights are and what the holder's rights are, why is that an argument for no rights?
Because I think, and I mean, this isn't my argument alone, but I think when you raise an entire generation that says the law doesn't apply to me because I don't believe in the law, or somebody has tried to teach me the law, and this happens to me. I try to teach people the law, and I get replies and emails that say the law is stupid. It doesn't matter. This is fair use, right? And that's like, that's very disheartening.
I've given talks to my kids' computer science classes at the lab school, and they think I'm from Mars.
Right, and I think once you raise an entire generation...
I'm really from Venus. But,
right. No, but once you have an entire generation that says these laws don't apply, right, then you have an entire generation that may also think other laws don't apply, or that there is an ability to say, this is so wrong that I don't have to believe in it.
Can we go somewhere else with copyright for a second and talk about Amazon Cloud Music Services? Because it feels like a tangent, but I don't think it is.
It's right in there. Yeah.
Okay, so what do they do in this? Let's fill everybody in on how Amazon's Cloud Music is working.
So, does anybody bought music from Amazon from iTunes? Have you ever lost the song or gotten corrupted and you want to download it again? You can't, right? And because they only have a license to sell you one copy, and they can't transfer another copy to you after your initial transaction. So what Amazon has done is they've given everybody, all their customers, 5 or 20 gigs of storage, right? And when they buy the song, they transfer the copy to your storage, which is assigned to you. It's yours. And once it's in your space, you can copy it as many times as you want. It's yours. And you can stream it. They put out an app that lets you stream it from your storage to their app. And so this looks, I think, for all the world like they've developed a new service, when all they've really done is sort of hacked the existing model for the service and said, well, instead of transferring it to your computer, we'll give you some cloud storage, and we'll transfer it to your phone. the labels freaked out, right? Because they don't have the licenses to launch that service that looks.
But the labels
Practically.
haven't filed suit yet.
They put out. This is what they do. They send me press releases that say, Amazon doesn't know what they're doing. We must investigate this. And then I have to like sit there and be like, the labels say.
So
right?
do we think, though, that's the thing, the point that Randy was making about what Rick says to his clients, which is like somebody is saying to the labels, wait, don't move on this yet, because this is your bread and butter now. You're not selling records at Reckless anymore. Virgin Megastores closed. This is the way you're selling music.
I think someone is saying to them, be careful. Yeah, I mean, I think that's why it's rolled out slowly, right? Because in prior situations like this, the Beam It example is the one that comes to mind for me, right? Which was the same kind of,
MP3.com.
right? Yeah, exactly. Which was a music locker in the sky, as it were, right?
But so the difference is there was no transaction with MP3.com.
No, I understand. The idea was I was supposed to be able to basically bring my CDs, rip those CDs, and store them remotely, right? So they were simply providing substitute storage for my local
But
storage.
you didn't transfer your bits to them.
No.
That's the big difference.
Well, tell me, okay, but you tell me why you think that matters.
Well, I don't.
Yeah, okay, I didn't think you did.
But I mean, the difference, I think, from the law perspective,
We can do, right, but you don't
to
really
distinguish the
think that
cases, because their argument, MP3's argument was this is functional fair use, right?
Right, I
Which
understand.
is, I mean, at the time, even I read that, and I was an undergrad, and I thought, well, that's stupid.
But think about how you set up this discussion, right? You set up this discussion as, they're sort of protecting you from losing songs, right?
I mean, MP3, their
I mean,
marketing was you'll get anything you want.
anyone have any broken CDs at home? I mean, part of that's a decision about how we allocate the risks associated with destruction of the content and the media, right?
Well, sure, but I mean, I think that Amazon's trick
They
is,
don't give me a free CD when I walk in with my broken CD.
you know, when all these digital services launched, I mean, I remember the discussion on iTunes was, well, Amazon can win, because all they have to do is sell you the CD and then sell you the digital content, because everybody still wants tangible physical media. And that was 5 years ago, and now nobody wants a CD anymore.
Must be the only person in the room still buying CDs, but I dutifully get them, I rip them and put them on my iPad. And
Well, you know,
move on.
what's all these alternative markets for digital media, they're all premised, you know, when you buy a CD, it's very simple. You have a CD player and you play it.
Right.
Digital media is premised on you have a computer, you know how to use it, you've connected to the internet, you're paying the fee, you have a portable device that you understand how to sync to your computer. I
Right.
mean, I can see why the record labels would be very hesitant to say, well, this is our new business model, selling it to this class of people
Right.
that understand how all these devices work.
Right.
But I think it's their future. I mean, I
Oh,
can't
yeah.
imagine they should keep printing CDs.
No.
And then if you, go ahead.
No. I'm curious about whether, DMCA was written in what, 90s, written in 97, passed in 98,
Yeah.
sometime in there? And it strikes me, DMCA and the Telecom Act, both written in the 90s, both written way before any of this stuff happened. But with the DMCA in particular, I wonder if it's just like, is it time for us to revisit this?
So, I mean, it's interesting, right? So think of the telecom. So we went from 34 to 96 on that. That's scary, right? I mean, you're talking about 6 decades before, and lots of stuff happened in the meantime, right? The DMCA, I would say that the people, and I also mean the industry who wrote the DMCA, got exactly what they wanted, and think they're probably happy with that statute, and they just want it enforced, right? I mean, right? The cynical thing would be they got the statute they bought
But-
and paid for, and now they just want to see it implemented.
But I mean, this goes right back to that PS3 conversation. Sony is enforcing its DMCA
Absolutely,
rights.
I agree
And the
completely.
backlash from this tiny vocal, and I mean, I do not agree
Right.
with their actions. The backlash is killing their business. The cost of enforcing the DMCA.
Well, and the ability to organize these group consumer responses has really gone up, right? And so I think that means the practical ability of firms like Sony to enforce their rights have dropped.
So I mean,
Right?
yeah, but AT&T won a case in the Supreme Court yesterday saying
It did.
we can.
But that's
we
just when
can-
contracts go to the court talk case, right?
Right, but I mean, at the flip side of that is, we'll hack your network to bits and shut down your
This is
business.
the arbitration class action case, which I printed but have not yet read. So
It is it's a master. Breyer's Dissent is
5-4.
it's pretty amazing.
Have you read this or
I
not?
haven't read it, but
Yeah. Okay.
I mean, it's.
I love-
You can tell I'm a huge nerd. I've left the law and I'm still like here.
Yeah,
That's good.
I love the way every time I come to a law school, it's like 5-4. It's like a sports score. It's like the Sox won yesterday.
No overtime. though.
Yeah,
Right.
Scalia scored a big one.
Knocked it out of the park.
Where does the 800-pound gorilla who we haven't talked about yet, where does Google fit into all this? Google Books. If we're going to talk about copyright at this point, I mean, is that at all a game changer? Is the technology
I'd
a
love
game
to take
changer?
Google Books, which I think I've written 3 papers on, a little cottage industry. So, I mean, we don't know where we are, right? In the sense that if you've been following the case, the decision sat there for basically a year. Judge Chin ruled in February, finally, and found that the settlement was simply too much, too far. The critical issue in Google Books is with regard to so-called orphan works. Those are the works where we can't identify who the rights holder is. If you're an academic like me, those are the books you want to see online, right? I'm not interested in bestsellers. I'm interested in the obscure. That's why I'm an academic, right? And so those are the books. You know, I wrote a paper recently on razors and blades, basically the history thereof, and Google Book Search was a godsend for me. I'm looking at the advertisements that Gillette was running in the 1920s and the 1910s. What a resource. But Judge Chin said that the sort of going forward arrangements that the class action settlement with the Authors Guild would have implemented was too much, didn't approve it, and Google basically hasn't said boo since then. So I think everyone's trying to figure out what to do. It's very easy to say, oh, we should have orphan works legislation. I testified on the settlement in Congress. Everyone understands that, and still no one does anything. So,
Well, I mean, this goes back to, I think, the big stakeholders in the Copyright Act. I think they're happy with it. I think they're like, well, we legislate copies, and that might not be what people expect us to regulate, but we've built our business on this model. And so rewriting the act, I think, is not in their best interest, because they have to rethink their businesses when you actually make that decoupling official.
but the orphan, go ahead.
Well, the only thing I was going to say is there is a little bit of a different perspective. Essentially, you could view it as a clever way for Google to uniquely be able to extract and capture all the value and make it impossible for anybody else to.
Well, no, I wrote a paper against that, so I'm with you on that, right? So I said, look, they're creating an orphan works monopolist.
Right.
They should multiply the number of licenses. That's what I pitched, right?
And maybe that would have worked. But if you look at how, I mean, again, I have the perspective of being concerned about their position in search. And the way they were making orphan works and the other stuff available to any competitor was essentially controlled by them.
Absolutely.
And so I think ultimately that's really what Google wanted to do. I mean, I think Google's interest was probably more in the area of search ultimately. So they probably would have been happy to give multiple licenses to their to folks who wanted to sell orphan work.
Yeah, but again, I want to distinguish those two.
Right,
Multiple
right.
licenses would have mean the whole kit and caboodle, search and,
Right. But again, I think that, you know, Google essentially, one could say, had a view that was not terribly respectful of the rights holders, was willing to, in a wholesale fashion, copy things without necessarily taking care of the rights holders if they got sued.
Yeah.
And it was, you know, part of the argument Amazon, speaking of Amazon, was making was, hey, look, you know, we copied stuff too, but we actually went out and negotiated the rights, which is inherently more expensive and puts us at a significant disadvantage. So the interesting question in the Google book settlement is, you know, again, a lot of people lose sight of this. All the judge did was say you can't have a settlement.
Right.
The case goes on.
Absolutely.
And there are some kind of interesting questions on fair use and how that applies in the search context.
Now, do you think, I mean, I'm always interested about the relationship between, you know, what do we think we accomplish in antitrust? So a question we'll talk about in my antitrust class is what did the Microsoft case actually do, right? I mean, okay. And do we think that the emergence of Google, for example, has anything to do with the final judgment that was put in place? Okay, different question. But here I'm curious, do you think Google felt free to be very aggressive about copyright because they weren't shackled by government scrutiny in the way that I point at Microsoft and point at you, but would Microsoft have been more aggressive over this dimension if they hadn't gone through?
I mean, you know, who knows? But
Yeah.
I don't think Microsoft would have. I think that part of, again, I think Neil said they're the most interesting company.
Yeah.
And part of the thing that is interesting about Google is they perhaps are guilty of what Microsoft used to be accused of, and that is drinking the Kool-Aid. I mean, they kind of believe in their shtick, and they kind of believe, I think there's an argument that they believe that what they're doing is right. They believe that it's very good for everything to be in the Google universe, for them to see everything, to control everything. They'll give people access to it. And again, there's sort of that pernicious, their product is really you and me, because they're basically taking us and selling us. But I think that is their product. But they do believe, I think, that it can't be bad that they have all this information. They're going to make it available to everybody else, but they lose sight of the fact that they're earning, which, money's fine, but it's $25 billion or so
It's 97%
every year.
of the revenue is
Yeah.
ads, right?
Oh,
Well,
yeah.
we were talking about In the Plex earlier, which I think really interesting book. It's sort of the Google biography, Deep Access, and there's this whole chapter on when they first put up Google and they're building the algorithm, and they're like, man, this is amazing. I can type in what time does this movie start, and we'll find it for you. And it's like, that's great. You've built a great search engine, but it's actually the data is what's important. It's you're the conduit to whoever else figured out what time the movie started.
Right.
Like you didn't figure that out. And I think that's kind of the Google is they've decided search is the vector that makes information important, not necessarily the information itself. And I think with books, do you move that to the state? Do you say, well, Orphan Works, we'll just give it to the Library of Congress. We'll let Google index it because they're really good at indexing, and we'll let the government figure out what to do with Orphan Works. Is that the sort of legislation that
We don't want a monopoly. I want to let everyone use it.
And you may want to let everybody use it, but look, the problem with Google is, ultimately a decision like that, do you really want it to be decided in the context of litigation and one company come out and become the arbiter, which
but
is
as
to
a
some
lawyer,
extent
you have to admire what they did there.
Oh,
right?
what you have
It
to
was
admire.
clever.
No, what was very clever was the
Okay.
way they used the class action process.
So the copyright system
but they lost
requires
on it. They did lose
consent,
on
and
that.
they tried to use the class action system to flip
Right.
that.
No,
that was clever.
It was clever.
Right?
But Google's
Okay.
entire strategy when it comes to IP is almost built on, we'll just do it, and then we'll go to court and say, these are all the arguments for why we should have done it. It's almost mp3.com writ large with $30 billion of revenue every quarter.
Well, their whole model is built on getting access to the data. You're right. It's generally not the data that they've created, which is why people who create things like news and everything else get very upset and nervous about Google. About getting it and getting it at as low cost as they can. And then, to some extent, maintaining control over it, because you can look at different areas where once they get access to the information, they tend to be far less open in giving other people access to it.
Well,
YouTube is a
that was
perfect
it. That's
example.
exactly where I was going. YouTube is.
Yeah.
I think Viacom can throw darts at YouTube all day and night, and that engine is going to keep turning, and they're never going to be able to pull every song off of YouTube that infringes. Google can build whatever algorithm they want.
But the interesting thing is that, like with YouTube and with other things, they once they have control of it, notwithstanding before they own it, their general mantra is it should be open to everybody to crawl and index. Once they own it, it's pretty much closed to everybody but them to crawl and index. So they, again, it's kind of like a black hole.
But
Things
so
get sucked in and they
Rick
never
talked
come
about
out.
the 96 Telecommunications Act. So one of the key features there, and the one that eventually goes to the Supreme Court, and the FCC figures out the rules, is about the degree of sharing and interconnection.
Mm-hmm.
Would you like that kind of regime vis-a-vis YouTube?
I'm not a big
Search neutrality.
fan of regulation.
Right.
Well,
Well, you're a Chicago guy. How could
right.
you?
I couldn't.
Guys from the college, I'm less sure. Guys from the law school, I know where we are. Right.
But I will say I am a big believer in litigation. And
Most lawyers are. Okay. Yeah.
so I think we can deal with the problem that way.
I want to turn completely at this point. So I don't think we've exhausted copyright, but I think that a lot of the interest in this panel may have been more about sort of the mobile device market and stuff like that.
Well, there's a way I want to get to it, which plays right off of what you guys just said. It's the Telecom Act. You just made a direct sort of connection between how we regulate telecommunications and how we regulate search, right?
Well,
And
I teach a whole course, my network industries course, where the heart of that course is and we start with the telegraph and move forward, is about basically interconnection rules. Okay.
Right, so that's great, but I mean, from my perspective now, and I think from a lot of my readers' perspectives, there is the access layer, which stops, and then there is the service and content layer, which is a thriving industry, right? And I would think they would see YouTube and Google and whoever else is living in that content layer, divorced from the access layer. So I don't know why it would be appropriate to regulate API access to search in the Telecom Act.
Well, when you say in the Telecom Act, I use that as an example of the kind of interconnection regulations that we have been willing to implement in some circumstances.
So where would you put that? I guess in what
God,
framework?
I mean, I can make up as many new statutes as I need to, right? I mean, that's not the issue,
Well, but you
right?
need. I mean, I'm just saying, what title would you throw that under?
You could throw it under Title 15,
You think?
Section 1, but.
62.
Or Section 2.
This is when I was like most terrified of.
Yeah.
Like,
No, but I think, I mean, there's an interesting, when I saw that this was an issue we were going to talk about, I don't know if you've seen Howard Shalansky's. Howard Shalansky.
Yeah, I know Howard, obviously.
Yeah,
Sure.
but he's a deputy director of the Bureau of Economics at the FTC and in charge of their Bureau of Competition. But he basically gave a talk, and it was really on network neutrality. But his point was, look, where you have to be concerned is where the bottleneck is. And conceptually, it doesn't have to be down in the guts,
Absolutely
whether
not.
it's spectrum or wires. It can be somewhere at an application layer. And from my perspective, it could be Google. It could be a lot of different.
Straightforward story on Google you tell is that basically as you watch people click the links, right, you learn things, and that learning engine effectively gives rise to a natural monopoly. That would be the contention, right? And the network industries class I teach is about the regulation of natural monopoly.
Right.
There's nothing layer specific about that.
But
That's your point.
yeah, that's
and
the
I
point.
agree.
And I will say the '96 Act, to some extent, although I think you could look back and say that what happened between '34 and '96 and what finally brought about the '96 Act was the breakup of Ma Bell and the antitrust regulation, and Congress decided that you needed a way to kind of segue through that. But there was this conception, really, in the '96 Act, a little bit of a vision beyond it, but that the bottleneck was always going to be at the guts, the kind of wire and the infrastructure level, which I'm not sure that it's entirely true today. I mean, there was kind of a vision forward that wouldn't be the situation forever, and to some extent it's not, because if I look back in the '80s when we broke up AT&T, and I was there at the time, and today, I mean, it's very different. And to the extent you want to talk about AT&T and T-Mobile, it's a very different industry today in terms of what happens down there at the infrastructure level.
Well, the
than what it was
'96
in
Act is
96.
about trying to create local competition in the landline market.
Right.
That's a dying market.
That's
I mean, so the premise. Go ahead.
Is it really a dying market?
Well, the
though?
numbers are.
Yeah,
I mean,
but
run the numbers.
I just
I'm not
got-
saying people aren't talking on the phones, landlines.
No, landlines,
Right.
but I mean, that's,
Right.
that same piece of copper is most people's now access to the internet in a real and robust way. There aren't that many people out there with LTE phones who are actually getting what would qualify in any country other than the U.S. as broadband.
the
Given
people
that
who
our
do have-
definition of broadband is still, what's it gone up to, 2 Mbps now?
Right.
I don't
And the
know.
people
There are
who
a lot of people there. I would disagree. I think you're going to see. And wasn't it the case that last year, for the first time, there were fewer subscribers, landline subscribers? I mean, the numbers are actually going down. People are sort of disconnecting. I know where I live, I've got the copper wire. I've got, in theory, a cable. I've also got fiber.
But
to
what
the
I,
house now.
let me just say, I just got back. If you look at the UK, where they've unbundled the local loops, that dynamic is not playing out because they have robust competition over those local loops now. Speeds over the past 10 years, services has improved by an order of magnitude. Prices have come down by an order of magnitude. there's still a very robust market on that copper.
Right, I took your point to be that even if what we think of as a local telecommunications market for voice calls is dying.
Right.
Your point was we still maybe only have 3 wires in the ground, and that's
Correct.
the issue we need
Yes.
to talk to.
Yes.
Understood.
Right, and
Understood.
when you have right now, the biggest landline providers are AT&T and Verizon, who also happen to be the biggest wireless providers. And you could say, well, LTE should be the competition for your local service. Verizon,
And the FCC does say that.
it should be, but Verizon, AT&T, they cap your LTE service. So I have friends in New York who have terrible Time Warner connections, right? They're really slow. I have a friend in New York.
Yeah, exactly.
And I would, my instinct here would be like, well, just buy an LTE Wi-Fi device, put it in your house. You'll get 20 megs down or whatever, but you can't because it's capped at 5 gigabytes of bandwidth per month, right? And that's ridiculous. That means it functionally is no longer a competition for your wireline service. And that's Verizon, I think, saying, well, we want you to get Fios. AT&T saying we want you to get UVerse instead of buy this one piece of access that can deliver every type of content that you probably want. And I think that's really, when I make the distinction between layers, it's the service layer has almost become a utility. And it's the content layer that is the market. And I think there is not robust competition at the service layer. I don't think AT&T and Verizon, their plans are within $5 of each other. And the pricing pressure from T-Mobile, which is much cheaper, has not moved those plans significantly in forever.
But the solution to this is to roll out that 500 megahertz of spectrum that the FCC keeps telling us they're going to get for us, right?
And why aren't we getting it? Why isn't it happening?
Well, because we know that there's, the heart of that's going to come from the TV broadcasters, and there's
Wasn't
obviously
that the 700 megahertz
a
spectrum?
big fight about that. I'm sorry?
That's the 7, they sold it to Verizon.
Well,
They
but,
sold
but,
the other chunk of it to
the
AT&T.
National Broadband Plan, make of it what you will, obviously contemplates rolling out an enormous chunk of spectrum for these broadband services. But a lot of that's going to have to come from TV broadcasters who think they're entitled to it,
Well,
right?
so that's the spectrum crunch argument. And I
Yeah,
think
yeah.
The big, AT&T,
But we don't
Verizon-
want more wires in the ground, really.
No, we just want more radiation through our bodies.
Exactly, as much as possible.
I'm glowing on the inside, glowing with data. Well, let me, the flip side, and this is the argument I've heard
You're against more spectrum?
No, I'm not against
Yeah,
more
okay.
spectrum. But the argument, and I feel compelled to present it, is that you look at AT&T. They want to buy T-Mobile and take their spectrum and do whatever they want to do with it. And they have millions upon millions of customers who are still on 2G devices, these old edge devices. And I think what probably costs them less than $39 billion, what they're going to spend on T-Mobile, to say everybody gets a new phone, and it's now 3G compatible, and we can repurpose this old spectrum. But that argument seems to have been tossed away in the wash. I mean, there is a certain amount of spectrum inefficiency that we have.
So what did you get out of a 361-page filing we made last week?
381.
81 pages. I have not read it yet, so
It is a delight, which I encourage none of you to
they
read.
filed this a week ago today.
A week ago today. So it's an antitrust argument, right? I mean, we're basically saying we'll buy T-Mobile and the market will still be competitive.
It's the FCC version of an antitrust.
Yeah, exactly.
Which is not exactly an antitrust.
Well, I mean, the FCC is very concerned about competition in wireless, right? And so if you look at the numbers, and this is the only chart I ever wanted to put up, but sadly you won't see it. There's Verizon, it has 90-some million subscribers. AT&T is around there, and then Sprint and T-Mobile are the other ones. They're going to buy T-Mobile, and they're going to be way bigger than Verizon, 120, and then Sprint will be at 30 million. So now we have a duopoly. And AT&T's argument is, well, T-Mobile sucks. And they're not competitive with us now, so it doesn't matter if we buy them, because Cincinnati Bell is more competitive in southwestern Ohio than T-Mobile. And it is 381 pages of this. I'm not even kidding. It is like put down after put down of T-Mobile. It is like, I was reading, I was like, we have to write about this because it's hilarious.
This company is so terrible that we have to spend billions of
Yeah,
dollars
30,
to buy
this
it.
is $39 billion.
Well, that's, that could be right, just so we're clear,
And
right?
it's true. T-Mobile is they're a failing company. And
Right.
And this comes back to devices. I think one of the reasons T-Mobile is failing, and Deutsche Telekom, which is their owner, says pretty much directly, they don't have the iPhone. If they had the iPhone, then their plans would be competitive, because people would say, well, it's cheaper and I still get an iPhone. But that's because we have device exclusives.
So tell us about the iPhone.
Well, it's this thing. It's about this big.
Meaning, so do you,
white
would you,
now.
would you, would you
Came out
apply?
white. There are
White,
lines.
exactly. What an innovation
There are
that is.
lines. This thing is 10 months old. There are lines today for the white iPhone. I mean, you cannot underestimate the demand for services that this thing causes.
So would you have barred the original exclusive deal between
This is the 5-year.
between Apple and AT&T? That's got to be the starting point for that conversation.
Well, so I don't. It's very strange, this 5-year exclusive. The only outlet that ever reported on it was USA Today. That was it. One mentioning USA Today.
There are leading technology.
That's when
yeah,
I look
okay.
for tech news.
Yeah, I go to
I
USA
do not,
Today.
I do not look at myself. I stare in the mirror every day. Why aren't I as good as USA Today? No, so the U.S. one mention of this exclusive when the first iPhone came out in 2007, and it was re-reported as fact, which is insane. Nobody ever confirmed it. And then there's the antitrust in California over the iPhone right now, saying this exclusive harms consumers. And Apple's lawyers point to the USA Today article saying it was disclosed. They don't confirm that there is an exclusive. They say if there was one, it was disclosed.
Let's assume there was.
Well, so it's weird to me because at the end of your 2-year contract, you still have an iPhone, right? The 5-year exclusive is I hate AT&T after 2 years. I want to buy a new iPhone and go to another carrier.
This guy who's never built a telephone comes to this company and says, I've got an idea. It's going to involve lots of joint investments.
Do you know? So here's what Apple meetings
No,
are like.
yes.
Every Apple meeting I've ever heard of has gone like this. They walk into the room, they sit down and say, we might do X. Would you be interested? And they're like, yeah, you're Apple. And they're like, all right, we'll send you a contract when we announce it after we're done. And that's like pretty much it. They don't tell you what they're going to do. They don't tell you. I mean, this is Apple. They're the most secretive company in the industry. Whereas Microsoft is like, everybody, check out what we're going to do. Please be interested in this. You know,
Well, that's because, the relative fortunes have tilted a little bit.
please,
and-
we'll send you 5, right?
I want to follow up for a second. Rick, you made the sort of a comment in passing. It's the FCC version of the antitrust argument with a little the hint of disdain. In
That's
your
because I'm an
voice there.
antitrust lawyer.
Yeah.
Where do you think this is going?
Well, I mean, there's kind of an interesting political dynamic to the way the Antitrust Division, the FCC, operates. And basically, and I'm sure this will be the same way, the FCC will largely look at the Antitrust Division to make the decision on the competition issues. And at least, I haven't read the filing, but typically if you look at what people put in FCC filings, they're not as sophisticated, I'll put it that way.
Well, they've got a lot from Dennis Carlton here.
Well, and Dennis is outstanding.
Across the midway at Booth,
Yes.
co-author of mine, I should say.
Very frequently used expert
I'm sure.
by me.
Yep, exactly.
So they've got good people. But again, if you just look at typically the kind of arguments that are made to the FCC, they tend to be a little more superficial. They tend to be a little more directed to the PR front.
I mean, it was sent to me directly. I mean,
Okay, well, there you
this
go.
is like a media argument. They
Yeah,
were
right,
like, look
right.
at this. We
And-
want your readers to understand.
And to Congress, and if you look at the FCC's mandate, it's really to promote and protect the public interest,
Yep.
which is a more general standard
Absolutely.
than what the antitrust agencies look at. The antitrust agencies, on the other hand, will look at, and people like Dennis will be very persuasive to them, and they'll make very sophisticated arguments, and they'll look at, I think, the contrast between, is it really true that the benefits from adding the spectrum that AT&T has, adding the spectrum, can they really generate all these benefits? Is it really going to, promote the rollout of 4G or LTE, more quickly than would otherwise be the case, which are basically their arguments, as against it's basically creating a duopoly. Now, the one thing I will say is and it's kind of an interesting phenomenon, which I'm not sure people really pick up on, but there is kind of a sense at the agencies these days that duopolies aren't all that bad. I mean, if you take a look at, for example, you can make the argument, and some people, I've heard some commissioners at the FTC take that away from the Oracle PeopleSoft argument.
That's interesting.
And you can look at the, speaking of Google and Apple, if you look at the Google ITA, not the Google ITA, but Google AdMob case. Ultimately, the reason the FTC didn't do anything in that case was because they thought that Apple was doing certain things to create another capability. I mean, that's what they say.
No. I
And-
consulted
and-
on the opposition on that deal, and we were making, I thought, huge progress.
No, I mean,
and then Apple went out and bought one of these companies and screwed the whole thing up.
Say that. I will say we were on the same side of that issue, but I will just say that I think there was a lot of support at the staff level, but the problem with the position was that it doesn't have to be a world between Google and Apple. There are other people who have mobile platforms. But part of the issue of Google having AdMob was that it took that away, which was kind of important for monetizing apps from every other platform that would be out there. And that was something that the FTC lost sight of. But if you look at it, I mean, there is kind of a view today that maybe duopolies aren't that bad, and maybe two is enough. So it'll be interesting to see in the AT&T T-Mobile deal that they might come away with the argument that it's better to have a stronger, better perceived by consumers network on AT&T's part fighting with Verizon than having T-Mobile.
I think that's, from my perspective, that is the entire argument, that access has become this utility, and the carriers will constantly point to the explosion in devices is evidence of competition. I think that's completely misguided, right? Having 1 million Android devices that are kind of the same, and the iPhone, that's great, and then that's the manufacturers doing it. But the only manufacturer that really thinks about the consumer and builds a consumer relationship is Apple. And if you go and talk to Samsung or whoever, they say our customer is the carrier. So now they only have 2 major customers, right? And they're not competing as ferociously as you'd like to see. And I'd like to see all of those manufacturers and all of those platforms begin to interact directly with the consumer and have the consumer say, well, I hate AT&T. My AT&T service is bad. I want to go take my phone, my device that I bought from a manufacturer, and plug it into a different service. And you cannot do that right now. You cannot,
But
there's
how does allowing this merger to go forward allow you to do that?
Well, so I mean, and I will openly say this is a naive and idealistic argument, is that this is a window for regulatory reform. And maybe that's wrong.
You really think the FCC is going to do
So
something?
you just mean that opportunistically, right?
Oh, yeah, right.
Yeah.
Well,
I don't mean it as real.
You actually have it, and I mean, again, it's an interesting sort of study more in politics than economics, but this deal is arising at a time at the agencies where they're much more willing to look at what you'd call behavioral remedies, which is another word for regulation, as opposed to
You just don't want to say it.
as opposed, well, the antitrust lawyers would never say they regulate, as opposed to structural remedies. Because for years, in fact, the old AT&T decree was all premised on the fact that you have to have structural remedies to deal with problems. And historically, until very recently, the only way to deal with problems in transactions was through some sort of structural relief, divesting some of the spectrum perhaps that they bought.
Right.
But if you look at things like the Live Nation case, if you look at the Google ITA case, if you look at a number of cases, increasingly the agencies, Comcast, NBC is another one, the agencies are moving more towards accepting behavioral decrees as opposed to structural relief. So it's not unreasonable, I'm not saying it's a good thing, but it's not unreasonable to expect that what would come out of the AT&T T-Mobile thing is some kind of behavioral decree.
Well, see, what I would ask for is, when Verizon bought the 700 megahertz spectrum, they did it conditionally. You have to put open access on your market. You have to be able to connect any compatible device. You have to run the app. I would say you could approve this merger and say, well, now you're under the same rules. And on top of that, you have to build devices that are interoperable with Verizon's network. The same chunk of spectrum for the most part, 700 megahertz. And I think that would reduce consumer friction. I mean, how many people in here have an iPhone AT&T? It's probably most of you. How many of you think AT&T sucks? Right?
Does anybody in here have a Verizon iPhone?
Right.
Are you happy with it?
Look at how smug he looks.
Yeah.
Now, let me ask you this. If you could switch, the people who don't like AT&T, if you could just push a button on your phone and switch, you would do
To
it.
T-Mobile, say. No, wait.
Well, T-Mobile's cheaper. If you could do that, that'd be even better. But if you could switch, pay the same rate, and get better service, you would probably do it. I mean, unless you have some blind affinity for AT&T.
There's a technology difference.
Well, yeah, right. I understand the technology difference, but if you could, would you? Right? No, you love AT&T, is what's
No,
happening.
I don't, but the fact is I can't
I know
travel
you're-
with the Verizon
can't.
iPhone to Europe.
Okay, right, so that's,
Yeah, but you may not be able to with the iPhone 5 either, so.
right. Do you want me to talk about iPhone 5? Or
Well,
I can do it all
actually,
day and
actually,
night.
we only have a few minutes left, so I want to see if we have a
Yes,
couple of quick
good.
questions that we can do out here. Yeah, back there.
Can you talk a little bit specifically about the ITA deal? I mean, I've heard that that may be the first shot really across Google's bow to push back on some of these antitrust issues.
Two shots, I think. I mean, in the sense, in the sense of I think the Google Buzz thing's huge. So, but talk about Google ITA.
Now, I think that there is a view that that was what the government was doing. If you look at the decree, there's a provision. It's kind of an interesting provision because I don't think I've ever seen it in another decree that essentially says, if you think Google is doing anything bad, please report it to us. Now, it doesn't really say what bad is. It just says that if it's unfair, and it's kind of an open invitation for people to raise issues about Google to the Department of Justice so that they can look at it. Now, technically, it's supposed to be related to travel because ITA was, dealt with travel. But I think it is a little broader. Some people thought that maybe they shouldn't be allowed to make that acquisition, that there were certain negative aspects of it that were pretty hard to deal with in a decree. But obviously, that's not how the government saw it. But there is that provision. I think the other thing that, you can look at the press and see, the Europeans are more broadly investigating Google. They started out with some specific complaints, but I think that's a broader investigation. And there's a lot you see in the press that the FTC and DOJ are trying to decide which one of them looks at Google more broadly in terms of what it's doing. And I think it's frankly, it's not unreasonable to expect that the people who, are largely responsible for the state of the law as it is today. I mean, Eric Schmidt was a big leader of the fight against Microsoft, which established a lot of the rules that are applicable to Google. A lot of their lawyers sort of were making those same arguments. And it's not unreasonable to say, well, let's kind of look at and see whether or not that shoe fits Google. And I think that's probably going to happen sooner rather than later.
I mean, the Google Buzz settlement puts in place a 20-year investigatory structure over privacy with the FTC. That's remarkable, right? So the way in which those together, I think changed the legal landscape for Google is pretty substantial.
I think Google is definitely, there's a lot of focus on them in Congress. There's a lot of focus elsewhere, and there are issues. There are people like some of my clients, other than Microsoft, that are suing them. And it's, it's an interesting company, and I think that, they're very sophisticated, they're very good, they are very interesting. And I think what they did in the Google book settlement in terms of being clever is pretty much indicative of, they're
Right.
well represented.
Exactly.
And I think that's pretty much across the board. But it's just at some point you can't get away with saying, look at our motto. It says we do no evil. And that should be the end of it. And it's funny, I'll tell one other little anecdote. I talked to the Wall Street Journal, and they had me, I wrote an op-ed about, 6 months ago. And I was talking to the editors, writing it completely in a vacuum, not realizing that they were also talking at the same time to Google. And the premise of what I said was, look, just saying trust us is not good enough. You have to actually, there are things that are out there that suggest that maybe they are violating the law. And there are plenty of examples that say that you can actually look at it. Just because it's complex technology doesn't mean you have to give a pass on it. So mine ran, and they ran one from a guy, I've forgotten what his name is, at Google, the same way. And it was amazing because I didn't know he was going to write it. And his whole thing was, this is way too complex technologically. People can't really understand it. It's really sort of beyond the capability of antitrust to deal with it. And I don't think he knew I was writing what I was writing, but it's just amazing. That's kind of their
But we
That's
go
one of
through
their arguments.
stages on that, right? So I think of the Microsoft 2 case, which sort of gets lost in the sands of time, right? The 2-1 decision about whether or not there was a contempt violation of the consent decree
Right.
as being very much a decision
What do
about saying
you view the original consent decree as
Microsoft won, the
Okay,
Tunny
all
Act
right,
case,
right,
exactly.
okay, all right,
Yeah,
right,
the
right,
Tunny
right,
Act
right,
case.
right, right,
So the Microsoft 2 case is very much a case which says, gosh, this is complex and hard, we should stay away from it. That's not how Microsoft 3 came out.
That's
So-
not, no, it's not. No, it's not.
So they'll get there, yeah.
Well, I mean, I think this goes back to sort of this culture that we don't regulate the internet. And I think they've become synonymous with internet culture. We're the smartest guys here. We'll do it. Just come, Google is in charge, right? And that is the mass perception of Google, that they are the smartest ones, right? And this idea that we
I don't know,
like,
Facebook is.
Yeah, I was going to say,
yeah.
Facebook's going to eat their lunch.
yeah, and then they're going to eat everybody else's
Well,
lunch
I
and
don't
take a picture of
know.
it.
I don't know
and
who the
it'll be
next
fine.
lunchy is. But,
You know, Google and
but-
Facebook actually have the same kind of internal conflict, right? Which is they make their money by selling your data, right?
But I don't think that's a problem. But I'm saying Facebook, I think it's easier for Facebook to go into search than for Google to go into social.
They're
And that's why
Backing into
Buzz is such a fiasco. And
well,
that was
Buzz is a structural fiasco. If they had done Buzz correctly, I think they would have
but a
gotten somewhere
legal
with it.
fiasco too.
Right. But it's
Yeah.
a legal fiasco because, I mean, literally the problem with Buzz, you guys know about Google Buzz? They try to make it basically a Twitter competitor, and everybody at Google only has Google contacts they talk to. So they said, screw it, we'll just make everybody at your Gmail, we'll public following list all of your contacts in Gmail. And then normal humans got access to Buzz. And it was like, my mistress is on here. Like, my abusive ex-husband is on here. Now he knows where I live and what I'm doing. And that's like, I mean, that is literally like just a Google founder mentality. It's like everybody should live their lives.
Transparency is always
Right,
good.
Right.
Right. But I mean, that's like, if they'd done that correctly, Buzz would have actually been a competitor. And they wouldn't. I mean, that's like a mistake, like a really dumb mistake that led to this regime. I think my question for you is that the right remedy to have this 20-year investigatory policy, or should we actually move? I mean, there's the FCC white paper in December.
Well, it's interesting because
I'm like the
well,
statist here. I don't know when I became this person.
But I mean, but you're
Like,
but in
sorry.
the T-Mobile situation, you're in favor of this opportunistic regulation, and that's what I see the FTC as effectively having done in the Google Buzz situation.
Right.
No, it's clearly, and you're right, the white paper, we did that in my tech policy seminar. It's a much broader inquiry, and that seems like the better framework. But it's so much easier to do these things opportunistically.
Well, when do you say? I mean, I think my question that I keep asking is, when do you say, well, okay, there isn't the internet economy, and we're going to see how it develops? When do you say the internet is the economy? We know what the shady aspects of the economy are. We know what confidence schemes and pyramid schemes in the economy look like. We know, and we think we have an idea of what consumers' reasonable expectation of privacy are in this market, and we can just legislate them.
Well, let me just say this. I mean, that's one of the benefits of litigation. If you, no, I mean, seriously, in this sense that if I go back to the late 80s and the early 90s, you could make exactly the same argument about PCs and operating systems and everything else. There was a lot of competition. One of the things that surprised some people when folks started focusing on Microsoft is, I will tell you, it's hard to understand maybe today, but the notion of using antitrust against software companies just generally was kind of a shocking notion, because for years everybody had thought about brick and mortar, buildings in the ground, things that I could touch and feel. And so software was the first place that you went to it. Well, what you can look at in retrospect is there was litigation. It was around Microsoft because there was this perception that this company, out of that chaos, if you will, had sort of emerged as the organizing principle. Mm-hmm. And you applied the law to it. Certain rules came out. I think the same thing is true. I mean, it's not all of the internet, but there is a part of the internet, and that is search and the importance of it. Okay, where Google is sort of emerging. At some point, Facebook may emerge as part of the internet, and it's sort of at that point when they begin to engage in practices that are harmful to others trying to compete or challenge them, when you probably ought to be looking at it and applying the law and seeing whether or not they're conducting themselves appropriately, and it just so happens that they're better than everybody else, and that's how they get to that position.
So this is
or
like a
they're not.
platform argument, right? I mean, it's
Right,
when does
but
your
and
platform
that's
get
pretty much
so
what's
big?
been happening. Yeah, and that's pretty much what's, all of these things are kind of platforms, and they're just platforms that have developed in different areas as technology has changed, as mores have changed. And essentially, it's when you get to that stage, the law imposes certain obligations on you that you have to take seriously. And if you don't, and if there are problems, then
But should there
somebody
be a
can look at it.
baseline for all these
Yeah,
platforms?
we gotta stop,
Real quick.
yeah.
Well, actually, some people have
Something.
class at 1:30, so anyone who
Yeah,
does, feel
that's
free to
fine. No,
leave
no.
now and go gracefully, and then people can stay. Maybe we can take another question or two for the panel. But yeah, feel free to go if you have class, and thanks for coming. And
Or if you've
we'll
had
have a
enough.
little bit more time.
We're extremely boring.
Actually, yes, since so many people are going.
Well, I want to thank Seth,
Yeah,
actually.
Seth,
What a great panel.
for coming, and thank you to all our speakers, and also special thanks to Chris Cooley, big help setting this up, and to SGFC for helping fund it, and to the rest of Link and everyone who helped make this event a reality. And yeah, if you guys have the time, just hang out, and if the panelists are willing, we can take another question or two.
Yeah,
or-
I mean, if anybody's left that wants to
Yeah,
ask a
yeah,
question.
we'll see how it goes. Great, thanks.
Yeah.
You talked earlier about the Sony hacking thing suing George Hotz, and I was thinking it's kind of a law and business question, because Microsoft, the Kinect was hacked almost immediately after it was released, and the way Microsoft dealt with it was they're like, okay, here's a dev kit for everybody to hack the
Well, they started out-
Kinect for us, right?
They started out much more poorly, right?
Right, right.
Their initial reaction was, don't do this,
Right.
you'll wreck the user experience, and nobody paid attention to them.
And then they turned around, and now Microsoft is like, everybody sees Microsoft as like, these guys are so friendly, and we love Microsoft for letting us
Right,
hack the
and I
Kinect.
think one of the reasons for that is that the most interesting thing about the Kinect is these hacks. Because the games are like, people bought them and now it's like the Wii, they're just sitting around. And I think they see the hacks from a media perspective as a way to keep the story alive. Like, look at all these interesting things people are doing with the Kinect. And you'll notice the story is never, look at all these Kinect games people are buying, or look at how awesome these new Kinect games are. That'll change, I think, in a few months. There's going to be another wave of games for the product. But
But from their perspective, Microsoft hadn't been cool in a century, basically, right?
Yeah.
And so the chance to look cool for just
this is the
I'm
coolest
quite
thing they've
serious,
done.
right?
Yeah, this is the coolest thing
That
they've done in a long
affects
time.
who's going to come work there and the like, and so that's clearly
Yeah,
the
and it's
biggest
big
value for
And,
them.
actually, there's an editorial on our site today that's titled "Sony, Please Be Sony Again." It's all about
They
how
were a
Sony
great
has
company.
mismanaged their image and their products.
That's been a century.
I'm gonna let you.
Well,
Microsoft, they made the century up. The Sony does go back, right?
yeah.
Exactly.
What kind of recourse do the users have? Is it against, can they have a suit against Sony for having that kind of breach?
Oh yeah, no. This is a class action process. I mean, every time, and this is I call them taco suits. It's like a terrible joke I've made up. So every time anything happens, I get 50 class action suits sent to me from all these opportunistic attorneys. And the funniest one I ever got was about Taco Bell. And they sued them because Taco Bell beef is not 100% beef. It's like 90% beef because there's 10% flavoring in there. It's like a ridiculous lawsuit. So I've been calling them all taco suits. I mean, I think the Sony one is, I think that's a little bit more, I mean, you have all these users who sign the same contract and the same user agreement. They've all suffered a really similar harm, which is tangible. Credit card numbers were taken. There's something in there. There's already been a case filed, I think, today. I imagine we'll see 3 or more state court cases. But I mean, it's all class action.
The taco suit has gone away, just in case you
The taco suit has
saw the
been
full page
yeah.
ads they've been running saying, give us an
Telebell's
apology.
now suing the law firm that
Exactly.
brought the
Yeah.
case.
Yeah, it's a
And
reverse
they're
taco
trying to
suit.
keep.
It's a double decker taco.
Yeah.
You got a follow-up on that?
Yeah, and also, recently, like for the new Mortal Kombat game, they've separated the online content from the tangible disc. Like, if they try to resell it through like GameStop or second user.
Right, and you need the code, you have to rebuy the
Yeah,
code.
so, do you see any kind of litigation on that of separating between like a first purchaser?
I mean, this is a first sale question, right? I mean, and they're telling you that your first sale right is only the physical thing and not this licensed content that's separate. And
It's
that's
quite plausible.
right. And yeah.
You should read the Blizzard World of Warcraft cases. Yeah. So,
I mean, this is like the whole you can't compete with reckless records argument, right? The way I would start to compete with reckless records is you would buy an inventory of content and set up a store and sell it, right? And you can't do that online, right? Getting that inventory is really hard.
Well, now we're really going to have to wrap up because actually a class wants to come in. After all, so thank you all for coming.
How dare they?
Thank you